In Granby, Colorado, a high mountain town in the Colorado Rockies, a general contracting construction firm, Contract One, was engaged in residential construction. Contract One directed one of its workers, Rosario Martinez, into an 8-foot trench to conduct work connecting freshwater supply piping. The trench collapsed, crushing and killing Mr. Martinez. OSHA issued citations, and then the local prosecutor brought criminal charges against Contract One's chief executive officer. We'll talk about the OSHA case and the criminal case on this, the August 25th, 2021 episode of the OSHA 3030. Hello, everyone, and welcome to the OSHA 3030 with Manesh Rath. I'm Manesh Rath, and I am an attorney at the law firm Keller and Heckman in Washington, D.C., and I practice in the field of occupational safety and health law, practice I've been engaged in for almost all of my 26 years of practice. And I'm grateful because I'm joined today by my dear friend and colleague here at Keller and Heckman, Javane Tartar, who has been a frequent contributor to the OSHA 3030 for a number of years now. Javane, thank you for joining us and welcome to the OSHA 3030.
Thank you for having me, Manesh.
Well, Javane, we have a great topic today. As you know, I think you may have actually been the one who identified this case. I think it's an important case. All of our topics that we've selected, I think, are compelling and relevant to this day, even though this is the 98th episode of the OSHA 3030, a series which goes back to to this very month in 2013. And all of them are libraried on our website, khlaw.com/OSHA3030. So for those of you participating in the OSHA 3030 today who want to check out other topics, I think you'll still find a lot of relevant, useful information, well organized by year, chronologically on our website, khlaw.com/OSHA3030. This is a program we do every month trying to feature developmental areas of occupational safety and health law, so that you can bring back practical takeaway knowledge back to your practices as in-house counsel or safety and health professionals. The only thing we ask of you in exchange for this complimentary program is that when you get the invitation for the next OSHA 3030 by email in your inbox, please forward that email on to at least 3 other people. Even if you've already done so, please forward this email on to 3 more safety and health professionals or in-house counsel who are responsible for or who would benefit from knowing more about the field of occupational safety and health law. So with that said, Javane, as I said, we have a great topic. This is a trench collapse, an unfortunate story, but I think one that is important because of the educational value that it provides for the employer community. And in particular, the construction community. We do a lot of work in the construction field in occupational safety and health law. And I think this is probably one of the most important areas of safety and health in construction is trenching and excavation. So let's talk about what we're going to talk about today.
Yes, we will be reviewing the facts of the unfortunate accident, the trench collapse involving the construction worker. We're going to go over OSHA's subsequent inspection following the incident and review the citations that were issued to the employer, Contract One. We'll also talk about OSHA's authority to issue criminal penalties under the OSHA Act and make referrals to state prosecutors for workplace violations, which is what occurred in this case. We'll analyze the Colorado State Court's recent sentencing of the construction company owner. And as always, we'll talk about what employers should do. And after our presentation, we will have an opportunity for participants to participate in the off-the-record conversation with Manesh.
This is a section where we'll turn off the recordings and just have a chat with members of the OSHA 3030 community who have questions about occupational safety and health law, general black letter law questions that we can answer. If we can answer them off the top of our heads, we'll be happy to. We ask that you pre-submit your questions if you're able to. But if you think of a question that fits that bill during this program, please feel free to submit it in the chat box and we'll take a look at it. Questions we can't address during the program, we'll try and get back to you after the program. So let's get into it. Let's talk about this trench cave-in. this involved contract one. This is a construction firm that does the pre-construction, the construction and follow-up on residential construction in the Rocky Mountains of Colorado, from Vail all the way up to Granby, Colorado. And a lot of ski area residential housing is a lot of the kind of construction that they do. And in this particular site, they had been hired to perform residential construction services in Granby, Colorado, which is just over the Continental Divide. If you go from Keller and Heckman's, let's say from Keller and Heckman's offices in Boulder, Colorado, and you drive west, before you get to Steamboat Springs, you would run into Granby. You would go through Grand County, Colorado, right over the Continental Divide, really the headwaters of the Colorado River as it begins its journey west. And here, up at maybe 8,000 feet in elevation, the residential construction was taking place. And one of their employees, Rosario Martinez, was initially hired just to do drywall and carpentry work. And his son was hired as well. And they were both on the job site on the day of the unfortunate accident. And contract one directed Mr. Martinez to go into this 8-foot trench and conduct some pipe connection work, attaching copper piping to the freshwater supply, to provide freshwater supply to the residential building that was underway. The trench collapsed and buried. Mr. Martinez was working on the connection process itself, so he was on his knees. And so when the trench collapsed, it buried him, and he was extricated from the rubble and rushed to a hospital. But ultimately, at the hospital, he died of his injuries. From excessive bleeding as well as a head trauma, and his son was on site, and I believe was one of the people who helped other workers to try and extricate him from the collapse. I mentioned these facts because I think that they tell some of the background behind OSHA's investigation and their decision to issue citations, as well as the criminal prosecution that ensued. But I think one more fact that's important: the trench had collapsed the day before and was redug, and the next day, contract one directed Mr. Martinez into the trench to perform his connection work. Well,
Right.
As with all fatalities, Javane, as you know, I think maybe one of the most important takeaway items is the duty to self-report.
Right. And so following the incident, contract one reported the fatality to OSHA. And so OSHA promptly investigated the site following the fatality. And according to OSHA, contract one failed to train Martinez and other workers to identify or avoid trenching and excavation hazards. And as you mentioned, the trench had collapsed the day before, and contract one did not incorporate additional safety measures. And so OSHA determined that contract one violated a number of OSHA standards and sought over $57,000 in penalties.
So OSHA issued serious classification violations for the excavation collapse and one willful. And the willful was failure to have adequate protective systems in place for trenching protections against cave-ins. This is interesting because, as you note here, OSHA has a national emphasis program on trenching that permits them to come on site where there are open and obvious trenching activities. They find these trenching alleged violations to always be at least of serious classification. And in this case, they found a willful violation. And I think the willful was premised in large part on the fact that they had discovered their allegation that there was a trench collapse the day prior and that work had resumed. But the work had resumed without any additional precautions being implemented after the collapse. There was no shoring, there was no protective works, trench works or bracing. The sloping was inadequate. They found heavy equipment on the side of the trenches was too close to the edge of the trench. And I think there was one more. The spoil pile was too close to the edge of the trench as well, Travane?
Right. So all of these were different violations of the excavation construction standards that OSHA identified that contract one did not comply with, and of course contributed to the trench collapse.
There were others that weren't proximate, in my view, to Mr. Martinez's death, but they certainly constitute violations, and I think if established, then they would constitute serious violations, as they were alleged. There was a failure to provide a proper exit, the ladders for proper exit. There was an allegation of a failure to provide training, as I think you mentioned, Chavne, for employees going into the trench. And I think it's an unfortunate note that Mr. Martinez was hired to do drywall and then was directed into the trench to perform the copper pipe connection work. And I believe he was alleged not to have received the proper training for safe trench entry and exit and safe trenching activities. So all of these they compound the picture of a long list of alleged failures on the part of contract one. So, Chavne, in addition to the trenching standard itself, the OSHA Act provides for the possibility of criminal penalties.
That's right. While criminal referrals for OSHA violations are not common, they do happen, and OSHA has the authority to work with prosecutors to obtain to pursue criminal prosecution of employers for certain OSHA violations. So Section 17 of the OSHA Act itself contains provisions for criminal penalties. So there are specific circumstances where OSHA can not only issue civil penalties, but also refer a case for criminal penalties as well. So for example, Section 17E of the OSHA Act, it provides it provides that any employer who willfully violates an OSHA standard and that violation caused the death of an employee, that can be punishable by a fine or up to 6 months imprisonment or both. And I believe the fine is $250,000 for individuals and $500,000 for organizations. So again, these are for willful violations, which are violations done with intentional knowing or voluntary disregard for the requirements of the standard, or with plain indifference to employee safety. And as we discussed, contract one was cited by OSHA for allegedly willfully failing to have adequate protective systems in place for cave-in hazards. So OSHA not only coordinates with the Department of Justice to do these prosecutions, but also they have partnerships with state and local prosecutors to prosecute employers under the state's own criminal statutes. So employers should be aware that OSHA could not only issue citations and work with the Department of Justice, but also they can prosecute individuals under their own state's criminal code.
And that's really what we see here, is that OSHA issued its willful citation as well as a serious classification citation items. And the criminal matter was undertaken by the prosecutor for Grand County, Colorado, the county in which Granby, Colorado sits. So the state prosecutor brought criminal charges against contract one CEO and owner Brian Johnson, and they alleged three different criminal violations: criminally negligent homicide, 2 counts of reckless endangerment, and a count of third-degree assault. The CEO, Mr. Johnson, pled guilty to the charges of reckless endangerment, both charges of reckless endangerment, and to the charge of third-degree assault in the form of a plea arrangement, which resulted in the prosecutor dropping the criminally negligent homicide case. And so here we see an alleged OSHA violation for the trench collapse, where the CEO and the company are embroiled not only in these civil claims, potentially the OSHA claim for certain, and now the CEO is facing criminal charges, and it results in a plea deal where he pleads guilty to 3 out of the 4 counts brought. which leads to I think some significant implications in the form of criminal sentencing. And I'll note, by the way, that this was a state prosecution, but federal sentencing follows strict federal sentencing guidelines where there's not much leeway in the form of plea arrangements, and there's not much leeway on the part of the empowered to the judge either when it comes to following federal sentencing guidelines. Finally, the other thing I'd say about federal sentencing guidelines is that there is a minimum percent of the time assessed that has to be served. So here we have state sentencing, and you see a slightly different picture. But I'd also point out that the 3 charges he pled to were the lesser charges when compared to the homicide charge. Javane, why don't you walk us through some of the features in this criminal plea arrangement, because I think that they are instructive in trying to understand the severity of criminal prosecutions for workplace safety and health matters.
Absolutely. So the judge in this case issued the sentence to Johnson on July 19th this year. And there were a number of different components to this. So Johnson was sentenced to serve jail time for 10 months and serve 3 years probation. But that's not where the story ends. Johnson was also ordered to do a number of other actions that relate to OSHA training and community service. So, for example, he was ordered to pay restitution to the Martinez family. And then for job sites that Contract 1 or Johnson have authority over, he is required to permit OSHA to inspect the site without having to obtain an administrative warrant. So he's supposed to permit these inspections. He is required to complete 3 different safety seminars or training events in the next 2 years, which may include OSHA's annual trench summit, OSHA's fall protection stand down, or events hosted by the Colorado Home Builders Association. He's also ordered to make charitable contributions to local charities, complete 100 hours of public service, and participate in the Department of Labor's Workers' Memorial Day ceremony in either 2021, 2022, or 2023. And then finally, he's also ordered not to personally commit any further willful or serious OSHA violations during his probation.
Some of these elements of the plea deal, such as undergoing safety training, the compulsory charitable contributions, or 100 hours of community service, or participating in the Workers' Memorial Day ceremony, they appear to have the quality of a civil settlement agreement, but they can be attached as conditions on probation. And so these are terms that I believe Mr. Johnson will have to fulfill within 3 years. Perhaps for the corporation, one of the most significant features is that both Contract 1 and the owners, which I believe are Mr. Johnson and his spouse, were required to allow OSHA inspection of work sites without requiring the agency to obtain an administrative warrant. They're essentially forfeiting their right to what I think is a right to request or expect reasonable search and seizure procedures. And that's a significant voluntary surrendering of a important right for employers. Not one that I recommend be used in every instance by any means. When OSHA seeks to conduct an inspection that may be duly promulgated by a complaint or a self-reported fatality, to seek an administrative warrant may not be the most efficient or profitable for the employer, but it is nevertheless a right that is reserved to the employer that in this particular case, Contract 1 and its owners have voluntarily surrendered to the state. So an interesting feature to this plea agreement. OSHA opined on Mr. Johnson's criminal sentencing in the form of a press release, essentially stating that they find these state prosecutions and federal prosecutions on the criminal side to be an effective enforcement tool, and they believe that bringing the criminal prosecution in the community in which an alleged perpetrator lives and the victim lives is a method by which the agency can secure a deterrence effect that also sends a signal to other employers that OSHA doesn't tolerate this kind of willful or allegedly criminal kind of violations of the standard. So that's the case in Granby, Colorado, and the criminal prosecution that ensued. Chavane, let's talk for a few minutes about what employers should do in light of this storyline. We covered, I think it was you and I actually who covered criminal prosecutions and a number of them throughout the country, and we predicted that criminal prosecutions would be on the rise in that episode of the OSHA 3030. It was about a year and a half ago.
That's right. That's right. We predicted that OSHA will be increasing its criminal referrals for certain OSHA violations because, as OSHA said in its press release, it believes that this is an effective deterrent and an effective enforcement tool. So we should be seeing more of these in the future.
One of the things I would add to that prediction is I think you're going to see more of them in trenching and excavation and in fall protection than would be a normal distribution by per standard. I think those standards will see a greater share of bringing out alleged criminal prosecutions or alleged criminal violations against employers or their owners or managers or CEOs. So keep an eye out if you are an employer engaged in those activities. We do a lot of work, as I said before, in the construction sector, and I believe that if you're in the construction sector, this is an incredibly important development or trend line generally. What can we do? What takeaway items can employers walk away from this case with as a lesson learned? Well, first of all, I think it's important to provide training for workers about proper trenching activities. And that should be a training program that goes to all employees that are exposed to trenching hazards. But in addition, as was the case with Mr. Martinez, when employees are reassigned from a different task to trenching activities, I think it's important for the employer to make sure that they're trained up. This is difficult because usually employees get reassigned from vastly different skill sets to trenching only because the employer is shorthanded and needs somebody to help immediately. And so it's precisely in that environment that stopping to provide proper training is the most challenging. And so that makes it a tricky piece of advice to take away and walk away with and execute effectively. But I think it is important. New employees and reassigned employees are, I think, a population in the workforce that are particularly high risk for employers and employees. And so that training program, that component of your training program is especially critical. I think the other thing I'd say is it's important to retain records of all of the training that is conducted with respect to trenching activities. I would say that this is true for all training on all modules of workplace safety and health. But this would include at a minimum the content that was delivered during the training program, who was trained on what dates, any refresher training. And the final component of records that employers should retain would be any method by which the employer has gauged or assessed the comprehension of the trainees. That would be written tests and demonstration methods of practical demonstrations of comprehension that a supervisor should record their notes on or observations on that practical demonstration by the employee, and thereby preserve a record that not only was the training conducted, but that the employee understood what he was being trained on. Javane, I'd say the other thing to talk about is the self-reporting. And I think if you could give us a few words about self-reporting as a requirement and what employers need to know so that they can comply with that requirement.
Right. So OSHA requires under its record-keeping regulations that if there is a fatality on a work-related fatality, that you must report this to OSHA within 8 hours, because again, OSHA is interested in coming to inspect the facility following the fatality, which is what Contract 1 did in this case. So it's important to ensure that that's promptly reported to OSHA right away. Also, I think an important takeaway here is this case illustrates that OSHA inspectors, when they come following a fatality, they not only are going to look for the OSHA violations and potentially issue civil penalties, but they'll be looking for possible criminal violations as well, to consider criminal referrals following the fatality. And so they may look to any willful violations, because then those would be the criminal violations. And so, following a fatality, employers should be aware that they should preserve any available evidence leading up to that, and make sure that they are prepared for not only potential civil but potential criminal penalties from OSHA.
Yeah, I think that's right. And I think it's important to understand that the inspector is going to come onto the site looking for some basic things in almost every inspection. What caused the incident or accident? Who all was involved? Who might have had opportunities to witness the event? But they're always going to ask about training, I think. I think that they're always going to try and find out what the corporate structure is and whether there are other establishments under the same control of the same enterprise. And as you said, I think they're always going to look to identify whether or not there was any evidence of willfulness or knowledge prior to the incident. I'd say, going back to this idea of self-reporting, to be clear to everyone participating that the duty to self-report applies to any fatality. And the duty to self-report is incumbent upon the employer within 8 hours of the incident. The duty to self-report also is triggered when there's what's called a catastrophe, and that would involve hospitalization, amputations, inoculation, hospitalization involving treatment, to be clear, that imparts upon the employer a duty to report an incident or one of those catastrophe events within 24 hours, and that the failure to comply with this self-reporting requirement is itself a violation. So that's something to be very well aware of, and to make sure that your facility establishment supervisors and managers are aware of as well, because that's really where compliance often has to happen. One more thing I'd say about preservation of evidence is that it's also possible for evidence to be accidentally destroyed through time or through automated processes or through the work procedures. And if you believe that there is the potential for any civil agency enforcement or criminal investigation, that it's important to preserve the evidence from destruction and not merely to avoid actively destroying evidence. And to record as much evidence as you can of your own, to take witness statements, to take photographs, videographic evidence, measurements, all sorts of sampling, anything that you think is going to be the kind of evidence that an OSHA inspector would take or a criminal investigator would take. You should try and obtain that kind of evidence for yourself as well. We have one of our valued and dear members of the OSHA 3030 community came in with through the chat box, an important point that I think, I'm sorry, I didn't think to mention myself, but he says, it's also important to record, to monitor for, and to record evidence of employee misconduct where it's applicable. That certainly is not the case in the set of allegations here involving Mr. Rosario Martinez, but there are cases where fatalities ensue from a series of events that include elements of employee misconduct, either that employee's misconduct or some other employee's misconduct. And that is critical evidence for the employer, for prosecutors, for OSHA. And there has to be a record of consistent monitoring for and disciplinary action and recording of any instances of employee misconduct. And I think the same is true, by the way, for near misses. We talk often about recording events, injuries, or illnesses, but that should also include memorializing any near misses and the causes or lessons learned from those. Okay, Well, that's it. One of our contributing members of the OSHA 3030 community happened to have the last word on this episode of the OSHA 3030. So that's it for this month's OSHA 3030. As many of you already know, we will rebroadcast this recording as a podcast, which we've been doing for a number of years. So please look for the OSHA 3030 on your favorite podcast app. And if you listen to it, please remember to like or rate the podcast so that it's more easily searchable and findable by others. And for about a year, we've been publishing the OSHA 3030 as a YouTube video as well, so that you can get the slides and the sound and the full webinar experience on YouTube. But we also library all of them, as I said earlier, on our website, khlaw.com/OSHA 3030. All of us are on LinkedIn. My colleagues, David Servati, Larry Halpern, Javanese on LinkedIn, as well as John Gustafson, Taylor Johnson, myself, several others in our OSHA practice are all on LinkedIn. So please link in with us and stay in touch that way as well. The next OSHA 3030 will be on September 22, 2021 at 1 p.m. Eastern Time, always on a Wednesday, always at 1 p.m. So please stay tuned for an email inviting you to the September 22 episode of the OSHA 3030. I believe it'll be our 98th or 99th episode. If I said a different number earlier, I think it'll be somewhere in that number range. And when you get that invitation, please don't forget to forward it on to at least 3 others who would benefit from updates on OSHA safety law updates. We have sister programs, the TSCA 3030, the REACH 3030, and the FIFRA 3030. Javane, these are areas of law that you engage in. I know you're going to be joining the Keller and Heckman team for a TSCA program called.
Oh, that is the TSCA Basics course, and that's going to be held in September next month. And so that is September 23rd. And so if anyone is interested in registering, let us know.
And the TSCA 3030 will be on October 20th. And you're also on the faculty for one of our upcoming FIFRA programs.
That's right. We are having a FIFRA primer, and that is September 29th and 30th. So again, if anyone is interested, let us know. We can send you the information.
Well, in baseball, I think we refer to you as a multi-tool player, being a valuable part of the faculty in all of these areas. So Javane, thank you very much for joining this month's OSHA 3030. Thank you all of our participants for participating this month. We look forward to seeing you again next month. And until then, stay safe.